Hi there, it's KMC, coming to you from the KMC University Help Desk. Had a very interesting consultation recently with a practice that had some really unusual things happening in the personal injury space. And I thought it would make a really good Help Desk question video because we get so many questions about this. Obviously, in the KMC University Library, we've got some tremendous training on personal injury, all the aspects of it, personal injury verification. But I want to just call out a couple of points here because of what we're seeing a little bit more of than we'd like to see. First of all, it's important to know that the state you live in dictates what personal injury looks like, auto accidents look like, where you reside and where your practice is. There are several different kinds. There is what we call no fault and PIP, where the person's own insurance actually has provisions to cover their medical costs. And then additionally, if there's a severe injury, there could be liability issues with an at-fault party for which the patient may choose to get an attorney or do other things to collect on not only their medical bills, but their pain and suffering and other issues from that liability party. Other states have what's called the tort system, which I want to talk a little bit more about today. The tort system means that in the cases of most auto accidents, the third party liable party, the liability party, is actually who takes care of kind of everything. And it is a we are suing you kind of a scenario. Now, sometimes patients can go after State Farm, who when Sally ran into my car, she has State Farm insurance. And most likely when a patient deals with that insurance on their own, it's a mess. That's the reason the majority get a third-party attorney who's going to be that intermediary between themselves and that office. Now, what happens with, or that payer, what happens with the office is a whole other conversation. Now, it is the gospel according to Kathy that we remember in all cases, but particularly in the case of something like a personal injury. Your patient owes you for the services they receive. We get lost in the sauce sometime and think, oh, well, they've got this and they've got that, and the attorney says they'll pay, and you act like a bank and wait to be paid, don't charge interest. And in almost every case, the attorney tries to knock down the fee and pay you less, etc. These are the points I want to make clear. The patient should always be very, very clear in the beginning that they are responsible for their bill. If they happen to have other aspects that might help them cover the cost of their bill, great. But most often, if you're in network, you've got some health insurance challenges, they're going to subrogate and ask for the money back anyway. If they have automobile med pay, that's really set aside to pay those bills along the way. More and more attorneys are saying, oh, no, I'm collecting that, and then I'll dole it out as I see fit. That is completely inappropriate. And they tell their patients, oh, no, this is how it's done. Bull, it's not how it's done. So what you should do is make sure you're properly educated so you can educate your patients. And if need be, stand your ground with attorneys that are trying to do something that's not proper. Now, if you choose to wait to be paid, I always recommend that you consider charging interest as soon as the case is discharged and you are waiting to be paid. Give it 30 days, whatever your policy says. But this gives you some leverage when they're trying to reduce your bill later to say, fine, I'll knock off the interest. But you do not have to be the bank. That is just simply not how it works. Some doctors will say, oh, Kathy, if I don't do that, attorneys won't refer to me. Do you really want to have those attorneys refer to you and have you be paid 50 cents on the dollar for the hard work that you do? And by the way, the patient got well and got paid. So I think that we're just got to get our minds straight about some of this. If you run into this situation, remember, you need to know what the status is of your health insurance. If you're out of network with a payer, you're under no obligation to submit those bills anytime. So make sure you're clear about that with the patient up front. If there's auto med pay, obviously PIP and other things work differently, but if there's med pay who's set aside on the patient's policy to pay their bills along the way, get that first and make sure that your patient has done all the proper paperwork, proper assignment of benefits, etc., to be sure that you're paid directly. Because once that goes on from there, all bets are off, and you are now becoming a creditor and waiting for that payment. Last thing I would say is make sure that patients know they might have an option to access a discounted fee in your office. But if that's the case, that's not insurance, and they must pay that bill along the way and get a super bill for the amount they paid. Doctors, please take back control and don't feel like you have to jump through the crazy hoops just to participate in personal injury claims. This is something where you should be paid properly because you got the patient better. In some cases, you waited to be paid without interest, and then we get knocked around at the end, and it just simply is not fair, and I don't want that for you. We'd love to help you if you have questions about this or need a little assistance. Please reach out to us at KMC University.